Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley, and this is Rebecca Malone from Malone Hatley PC with our podcast, I Now Pronounce You Divorce, where each week we talk about things that we see our clients going through that we think are important, or issues that we've read or learned over the previous week that we just want to bring to the forefront for anybody out there who's thinking about divorce, or any divorce practitioners who just happen to be listening. So this week, we're going to talk about the idea that there's an increase in divorce rates in March and August. And, you can look at those two dates and say these are kind of well timed around Valentine's Day and spring break, and then the end of summer. And that's what we've seen in our practice as well. Right, Rebecca, in March, we see an influx. March, April, we see an influx. And then again, in August, we see an influx. And when we're talking to the clients, it becomes very clear why that influx persists, but it may not be on its face. So can you tell us a little bit about what's going on there?
Right. So the March one, sometimes that's a little bit also of a carryover from the first of the year. Oftentimes, folks will feel like they just have to make it through the holidays. They have to get through Christmas. They want to get through New Year's. And that's when they start sort of that initial conversation of maybe it's time to separate. By the time that conversation progresses in March, usually that's when someone actually ends up filing and moving their case forward. In August, what we see is a big influx right before or right kind of when kids are going back to school. And that can be for a number of reasons. It may be, again, the same sort of psychological thing of getting through a summer vacation, maybe, doing some traveling or going on family reunions, something like that. We want to get through this. And now that we're back and we're into our normal routine, now we can move forward and actually separate and move apart. Another reason, though, can be related to the children's school registration and the school routine. And so if you have a parent who wants to relocate or something like that, they probably won't be allowed to while the child is in school. The court doesn't want to see kids be uprooted sort of out of nowhere, out of their regular routine and their regular school environment. And so those are a few of the contributing factors to why we see that big spike around March and why we see it again in August, usually around the end of August.
And both of them have one thing in common. It's being around each other, right? Mm-hmm. When we're able to escape to work, sometimes, you go to work for 8, 9, 10 hours a day. You come home, you sleep for 8 hours a day. There's not that much time left to have an interaction with your spouse, who you may not actually like. Summer break usually exacerbates the roles, right? So you have the kids out of school. You have one parent who maybe doesn't want to I don't want to say not be involved, but maybe their job doesn't allow them to take as much time off, or maybe they don't perceive that their job will allow them to take as much time off. And the other parent is shouldering all this responsibility and says, there's no difference right now between me being a single parent and me being married, except I have to make one less dinner. That's it. And so you see that exacerbated, and the holidays always exacerbate things because of family, right? You're around people. And if you don't like somebody, having to go through another Christmas and pretend and, go through another New Year's and another Valentine's Day and do all this pretending, it gets old. But one of the things that you brought up that I'd really like to explore more is the school enrollment. You're 100% right. The courts do not like for you to change the children's school unless it's a necessity, right? Now, let's say both parents get transferred. You're going to change the school, nothing you can do about it. But, is there, Rebecca, kind of a play in place to try to say, ooh, let's get the kids enrolled in my school and then watch what the court does?
Yes, absolutely. So the courts can't move that quickly. And if you have a situation where kids have started school somewhere, maybe in a new school district or something else like that going on, it'll probably be several weeks before you can get in front of a judge and have that issue heard. And at that point, again, the court is going to be hesitant to say, okay, we're going to remove the children from their new school that they've just met the teacher. They, know all the classmates, they're in a routine, they're in a schedule. Now we're going to move them and make them go to the school they should have been in the first place. So there can definitely be some strategy going on in those situations. And we've seen cases where a parent will very suddenly move across state lines. They'll move across the country, and they'll do it very, very close to that school time. And so they'll leave the very last week of August, enroll the kids in school, and then they get started. And by the time the other parent can react and file something and get in front of a judge, now there's that argument of, oh, but we're, secure and we have this great place and, the kids love their teachers, or whatever those arguments are. There can definitely be a lot of strategy behind that. That said, I have seen a lot of times where judges will order that the kids be returned to whatever their home jurisdiction is and be re-enrolled in the appropriate school, wherever that was supposed to be in the first place. And so the parent who's tried to do this and uproot the kids now is going to be holding the bag on all of those expenses. And so we've seen where someone will make this big dramatic move. They've paid for a new apartment. They've put a security deposit down. They've paid movers. They've done this. They've done that, only to be told by a judge, now you have to undo it all. And, surprise. So that's not something you want to take on lightly. But it definitely can be successful given the right circumstances. If you have, like you said, both parents are being relocated, maybe they're both military or they're transferring or something like that, there can be legitimate reasons, but oftentimes that's behavior that's going to be penalized by the court.
It is, and I ultimately think that that's the right decision by the courts.
Mm-hmm.
Even in my short time of practice, which relatively, is relatively short compared to, there's people that have been practicing for 60 years. I've seen a switch in the way judge handles this, because it used to be just whichever parent would steal the children and go enroll them in whatever school they chose, that parent ended up winning.
Right.
And we would have people walk in, and all of a sudden, summer hits about July, the other parent disappeared, has refused to turn the kids back over, has refused to cooperate in any sort of custody and visitation exchanges, any sort of conversations regarding this, even if there is a custody. Knowing that by the time we can get into court, school will have already started. So at the end of July, you might as well say anything bad you do at the end of July, I can't undo it as an attorney until school starts. Even through emergency motions is going to be touchy.
Right.
But like you brought up, judges really started to become aware of the fact that this was a game plan. And even if it wasn't a bad parent or an attorney really trying to game the system, even mentioning, oh, yeah, I guess if you wanted to move, you just go ahead and do it before school starts, plants the seed. And so I was really happy to see judges start pulling kids back to the home school, because, I had a case where the mother was doing this every August. Like at the end of August, she was taking the child and moving, and then the father would spend all school year getting an order put in place. Finally, we had a judge kind of in rural Virginia, south of Richmond, who put her foot down and said, nope, because the mother had then moved from Richmond, where the father had moved to Richmond, chasing after the child, trying to be in the child's life. Then mother moved down to Georgia somewhere. Judge put her foot down and said, nope, put this child back in the Richmond school. And ultimately, it took a while, but we did get dad sole legal, sole physical custody. And mom was only allowed to have supervised visitation because she kept pulling this stuff. And, you say, oh, well, she only did it 3 times. Well, that's 3 years out of that child's life. So when you have a client who wants to play this game, you said there are reasons, right? Like I got transferred for school, or let's say that there's some sort of abuse happening in the home,
Sure.
and the parent leaves with the children and moves in with their parents who happen to live across state lines.
Mm-hmm.
There are things. Can you kind of walk us through what advice you would give and what would count as a legitimate reason to move?
Right. So any sort of abuse, if there's an emergency of some sort, there's a risk to somebody's health, safety, or welfare,
Mhm.
those are going to be different cases. But with that said, you can't just file, or you can't just file your divorce and move and let that be it. In those situations, you really need to pursue getting some sort of criminal charges filed, if that's going to be applicable, getting a protective order put in place so that you can be safe. And that way there's also documentation of the reason for the move. And it isn't just some sort of strategy to get a leg up in the divorce case. If there's abuse happening against the children, you can also petition for emergency custody. And in those situations, you can get a hearing in front of a judge a lot more quickly, and you can get intervention based on some sort of physical violence or abuse or neglect that the children are going through in that situation. Absent something like that, you have to ask for some sort of permission before you can just move and relocate with the kids. And so what that looks like is first giving the court some type of notice, I intend to relocate, and then also asking for a change in custody or asking for an order to be put in place while your case is pending, while you're going through that. I've had situations where, for one reason or another, both parents are moving. And so we still have to go. Let's say everybody lived in Richmond and one parent moved to Northern Virginia and one parent moved to Virginia Beach. We still have to go probably to the Richmond court and figure out where are we going to transfer the case and what are we going to do sort of in the intermediary phase while we're figuring out where the case is going to be held and what the final issues are going to be. So again, you want to take action with the courts first and say, this is what I'm doing, this is why I'm doing it, and so I'm asking the court for some assistance because this is legitimate. So if you go through and move and relocate and you don't tell anybody and you don't file anything, it's not going to look favorable, to you later on in the case.
And you're talking about in situations where something already existed, right? You're not talking about in situations where there's been no divorce filed, no custody and visitation things filed
Right.
yet, where you're just talking about separating. You don't have to go to the court at that point,
Right.
but what you should do is reach out to the other person.
Mhm.
Absent any sort of abuse or any sort of things that would make you fear for your health, safety, and welfare, like your example, okay, we're separating. My job's up in Northern Virginia. You got a really good job in Virginia Beach. You're going to need some sort of resolution. And I say this with hesitation because the courts are getting better, but I hate to say it, mom's going to win in that case 100% of the time. If you walked into the Richmond court and dad was moving to Northern Virginia and mom was moving to Virginia Beach, mom wins. Unless dad was a stay-at-home caretaker and dad's moving to Northern Virginia to continue to be a stay-at-home caretaker, but that's not how that would happen. Both parents are equally situated. And I've had that conversation with fathers who've been in that exact situation and said, look, I hate to tell you this, we can go and put on the best show in the world. All things equal, mom will win. And in those circumstances, I have to tell dad, look, before anything's filed, you have to be the better parent. You have to know where the child's going to be enrolled in school. You have to be the one that go gets the 2-bedroom apartment. You have to be, or at least a 2-bedroom apartment, right? If it's one kid, having a room for you and the room for each, a separate room for the children. Knowing the where the children are going to go to school, knowing the bus route, knowing the teachers, and even in that scenario, the other side still has a leg up. Mom still has a leg up. I hate to tell you this. So, that's just the type of court system we live in. And to give a wonderful example of that, I represented somebody one time. I represented mom, and the child didn't have a home. Mom just went and stayed with her boyfriends at the time, and she had a lot of boyfriends. Dad was this very successful person who had a very nice home and had planned to put the child in private school. Mom won. And even when I got the decision, we always advocate for our clients. Mom won. And I was like, this child would have had a much different future if the parent with the stability won. So how do you handle talking to your clients about the realities of the biasnesses of the court?
Yeah, so it does always come down to the best interest of the child. But a couple of the factors that weigh really heavily on the court are what role each parent has taken in the past and what relationship each parent has with the child. And so if you have one parent who's been that primary caretaker, they're fixing the breakfast and packing the lunch and getting them from school and doing the doctor's appointments and taking them to the dentist and making sure vaccines are up to date. All of those everyday things, that's going to weigh really heavily with the court to say this parent has been the primary caretaker, and it's going to take a lot to overcome sort of that presumption that they should continue to be the primary caretaker. This is what the child is used to. This is what the relationship has been for the child with that parent. And so to make some sort of drastic change for the child, there has to be a big reason to do it. And it can happen, but like you said, it's very unlikely because the court is really looking for what has been normal for the child, what has been their routine, and how much can we kind of preserve that going forward when these parties are no longer going to live in the same house together.
And absent evidence, the court will assume it was mom. And that's why, I tell our clients or fathers, I said, hey, for every one thing the mom brings, we got to bring three. So, if you are the primary caretaker, you have to bring pictures of you making breakfast. The court's not going to assume that you were the one that made breakfast. We have to show that you were the one that took the children to the doctor for most of their appointments. So we have to subpoena the doctor's records to see which parent was there. We have to show that you were the parent that showed up for parent-teacher conferences, right? And didn't just start showing up for parent-teacher conferences 1 month before separation. And, that stuff is in the records. It's parent-teacher conferences. We've subpoenaed that information a lot, and it's amazing. It's always there. Who showed up to the teacher conferences, and the teachers remember you. Even the parent that picks up in the pickup line, like if you pick up in the pickup line. We've subpoenaed a bus driver and said which parent was waiting at the bus stop. And, all of that has gone in favor. But I always tell people, there are certain things that we still have to deal with, right? The courts are getting better, but absent evidence, the court's going to assume mom was the primary caretaker. And the court's going to assume dad was the one that was out working. So if you want to show that dad was actually the primary caretaker, you have to put together a good packet of evidence to show that. And then, we talked about moving prior to anything being filed. You can't just move and not tell anybody, right? Can you kind of walk us through what the best way to do that is?
Ideally, you want to have an agreement. If everybody's separating and moving away, and we have to have some sort of plan for this is how this is going to work going forward. Are we going to meet in the middle to do exchanges? How are we going to split holidays? Are we going to do some sort of FaceTime calls? How are we going to handle travel? All of these things, ideally, you want to have them laid out in some sort of an agreement. And that way you have something to show the court if someone doesn't do what they're supposed to do, right? So if they don't show up at the meeting spot, if they don't return the child when they're supposed to, they're not doing the FaceTime calls. You want to show evidence of this is what our agreement was. And this is why I agreed, that we could relocate or they could move there or whatever it may be. Even if you only have that written agreement, you can request enforcement from the court. It's not going to be the same thing as a show cause, but you can request enforcement from the court because you have that binding contract. There's a little bit more layers involved because it's children and we can't just contract for children willy-nilly. There has to be a lot of evidence and we got to make sure kids are safe and all that. But that's your starting point. At least you want to have something in writing, some kind of documentation showing this was agreed to, this is why, these are the circumstances, this is what everybody's responsible for. If you don't have that, you probably shouldn't just up and move because you don't have any kind of guarantee of what is going to happen. And so again, if you get ordered to move back, that's going to be huge, right? That's going to be hugely impactful on your finances, on your career, on the kids, on everything. So that's not a situation you want to be in. You want to either get that agreement signed and written and documented, or start filing something and get a court order before you end up moving.
And, getting a court order, I know that you know this, but it's easier said than done,
Of
right?
course.
I had one where mom at the end of the school year decided to take the kids out of school, move them from Virginia to North Carolina. We filed at the end of the school year. By December, the judge still refused to have a hearing on it. And even the other attorney who was representing mom, and this was completely in mom's favor to not have the hearing because school had started, mom had enrolled the kids in North Carolina, dad was trying to fight it. Even the other attorney filed something with the bar against the judge saying this is ridiculous. Like, you can't do this. Fortunately that judge was invited not to come back to the bench.
Yeah.
Because, they had a history of that. But there are certain situations where it's completely out of anybody's control. What do you do in this situation where, we talk about having agreements, and agreements are wonderful, but sometimes, well, let's be honest, most of the time there's not an agreement because with custody and visitation, it's a winner take all. There's not a lot of split reality. Like if one parent's moving out to Northern Virginia, one parent's moving to Virginia Beach, that's not, hey, I'll pick the kids up when they get out of school. And then you drop the kids off at school. It is one parent's going to get the kids for roughly 4 days a month, and the other parent's going to get the children for the rest of the month. and you can't have an agreement and both parents move. What do you advise your client in that situation?
Well, we go through what's important to them. What do they want? You know, if the likelihood is that they're not going to be the primary custodian, then is this still a move they want to make? Or would they rather change and start looking for jobs that are going to be closer to their children, that are going to accommodate more visitation? There can be reasons why they prioritize one thing over another, but that comes down to just talking to the client about what's most important to them, what the realistic outcomes are going to be, and then walking through that decision making process. It's impossible to know what to decide if you don't know, the possibilities on the other end of your case. And so that's one thing that we do, is we just walk through, well, what are your priorities? And then we can guide them to say, well, in your case, it makes more sense to do this. That way you're actually getting the thing you want, which is either primary custody or shared visitation or something to that effect.
And asking clients what they want 5 years from now, I found is a very good undertaking. I'll give the example. I had a client who came to me and was like, I don't want to pay child support. Well, in my attorney brain, there's only one way that my client couldn't pay child support, and that was to get him primary physical custody. And we did. And when we did, mom was like, great, I don't have to deal with kids anymore. She left. And he called me one day saying, I never wanted primary physical custody of my kids. I didn't want to pay child support. And I was like, I forgot to tell you what that meant. And he wasn't that unhappy. He just, the reality of having to take care of his several children kind of hit home. And having that conversation, where do you want to be 5 years from now? Do you want to be the primary physical custodian? Or, as bad as it is, parents on both sides, we've had mothers and fathers walk in and say, look, I want to be the every other weekend parent. I'm not going to lie. That's what I want. Yeah, I've been married since I was 18. I'm single again. I love my kids. Of course I do, but I would not mind being the every other weekend parent. I've had parents come in and say, look, I don't want the kids on the weekends. I will do all of the hard work. I will give every weekend to my soon-to-be ex-spouse. We're usually able to come to some sort of agreement on that. But the hardest part is when you have two good parents who are equally involved in the children's lives. Like, is very common, right? When you have two working parents, you have parents that are equally involved, and neither one of them wants to give the children up for very altruistic reasons, right? They both love the kids and want to spend as much time with them as possible. They're not just trying to get back at the other side. And geography, it's not even their hatred of the other parent that's causing the problem, it's geography. And sometimes, especially in Virginia, we get people that are relocated to the Pentagon and people that are relocated to the naval base in Virginia Beach. That's not uncommon. And that is not an easy drive. And in those situations, you have to talk to the client about the risk. Where neither parent's willing to agree. You have the middle ground being Richmond, school's getting ready to start, and neither parent lives there anymore. That's mutually assured destruction. And that's when I tell people, look, you've got to, whoever enrolls the kids in school first is going to win. Let's be honest. And unfortunately, that's how this is going to shake out. And this is not legal advice whatsoever. There's a lot of analysis that goes into that, but there are situations where that is going to be what shakes out. So, as we're coming towards the end of summer, I advise people start keeping a lookout for what's going on, right? If you know that you're separating from your spouse, have an open conversation. If you have children, where are they going to go to school? What are we thinking about for school? Try to keep them in the same school. Because if you really care about the best interest standard of the children, which is what the courts use, it's going to be continuity for the kids, right? What can we do to lessen the impact on the children? And, if you have like an 8th grader who's getting ready to go into high school and all of a sudden you move them to a completely different county with people they've never met before on a curriculum they never used before, that's not continuity. That's just being mean to the other parent. And we see that a lot. So, keep an eye out. If you want to move, or if you think your spouse is going to move, you need to contact an attorney. And you need to start talking about, hey, what would happen? Maybe I'm not ready to file for divorce yet, but I need to start taking these protective measures and be ready. So if you or somebody is thinking about divorce, is thinking about separation, give Malone Hatley PC a call and see the difference that a partner can make in your case.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.